Meanwhile, chatting today with Kalamazoo attorney Rich Migala, who is joining us to talk a little bit about the Jason Dalton case. Good morning, Rich.
Good morning, Richard.
Thank you for the time today. You know, when we first discussed talking, we were talking about this Uber suit, which ended up being a hoax. And
not surprisingly.
I guess not, but the strange part is, how does a fake lawsuit get as far as it did?
Well, anyone can file a lawsuit. So, no one looks through the pleading. It just goes to a clerk. As long as you pay the filing fee, it goes into the system. It's only once it's in the system that everyone starts looking at it.
Wow. So, yeah, this thing got written up, and somebody did a little bit of homework anyway. And if you saw the picture of what was handwritten, there was even a prisoner number on it and all of that stuff that made it look legitimate. But after a while, it quickly was discovered that, it wasn't legitimate. But that's really interesting that it goes to a point where it can get such attention and the whole thing is fake.
Yeah, I mean, again, it's a civil suit. I mean, anyone can file one, and it's as simple as like a lot of people represent themselves in the defense of a civil suit. I mean, they just write a handwritten letter, and the court has to kind of, once it's filed, it gets filed, and the court accepts it. But whether it's an acceptable pleading at that point, you have to have a hearing or whatever to determine that. Mm-hmm. But I've seen a lot of people just write a letter saying, I don't know it, or something like that.
Wow. It's possible, I suppose, to look at this and say, boy, I wonder how often this happens. We spend court resources vetting these cases that end up being a waste of time and money, but I guess that's what they're there for. Well,
and because it costs $150 like in circuit court just to file a complaint, what's called a complaint, you don't get it that often that it's a hoax just because of the expense of it.
Mm-hmm. But somebody was willing to pay the money this time.
They got a lot of publicity out of it.
Yeah, right. I don't know to what end, but I guess it stirred folks up like they wanted.
Well, supposedly the person responsible for it is known for doing those kind of things.
Oh, boy. All right. And that's not illegal, is it?
No. Well, actually it can be. Okay. If it's a civil one, I think I have to research that. But if it were a criminal matter, it could be, because it'd be like filing a false report.
Yeah.
But, I mean, from a civil perspective, it's not a criminal issue, but a judge could sanction the person for filing a frivolous lawsuit.
All right.
But this person, as I understand, was in prison anyway, so I don't think he was really concerned about that.
I guess it makes sense. They had a lot of time on their hands to sort this out. All right. We're talking with Southwest Michigan attorney Richard Migala. When we come back in a minute, we'll talk about the progress of the Dalton case thus far and Rich's impressions of that when we come back in a minute. Attorney Rich Migala is with us this half hour. So I guess it's not a surprise, and you can tell me if you see it that way from the legal viewpoint, but not a surprise that Jason Dalton was ordered to have a psychiatric evaluation.
Well, it's not a surprise from the standpoint of if a defense attorney or a defendant asserts a defense of insanity, that's referred as a special defense, and the defendant is required to give the court and the prosecutor advance notice if they propose to use that as a defense.
I see.
It's an affirmative defense. That requires the court then, as a mandatory event, to have the person shipped to the forensic center for psychiatry in Ypsilanti to be evaluated. It's a mandatory action because of that defense. Then the person has to be evaluated to determine if they meet the criteria to be considered insane under Michigan's criminal law.
So let me
mental health code.
I see. Let me make sure I understand that. It takes a defense attorney to say that they might invoke that to trigger this evaluation.
Right. It's what's called an affirmative or special defense. And the interesting thing about it, in a normal criminal trial, a defendant has no burden to do anything. it's the prosecutor's burden and the people's burden to prove that this person is guilty beyond a reasonable doubt. A insanity defense is an affirmative defense, and it shifts the burden, now the defendant's burden, to prove that the defense of insanity. But the interesting thing is, they only have to prove that by a preponderance of the evidence. Instead of the prosecutor having to prove someone's guilty beyond a reasonable doubt, the defense only has to prove that the defendant is insane by a preponderance of the evidence, which means more likely than not.
Wow. So, yeah, go ahead. I'm sorry.
And so you might think that defense would be used a lot more than it is.
Right.
But it's an extremely difficult burden to meet that the definition of insanity. In Michigan, a person is defined as insane if that person lacks substantial capacity either to appreciate the nature and quality or the wrongfulness of his or her conduct, or to conform his or her conduct to the requirements of the law due to either mental illness or what we used to call retardation.
So this evaluation that will be conducted then would determine what exactly? What would be the outcome of that?
Well, the psychiatrists would render an opinion whether or not the defendant is insane and was insane at the time of the event, and there's several things. They could be found to have been insane at the time of the event, but now they're mentally competent. That we used to have what's called a diminished capacity defense in Michigan, but the Supreme Court took away that defense in 2011. And then there's also guilty but mentally ill, which means that the person would still be found guilty of a crime. The only thing is when they would be sentenced, the Michigan Department of Corrections would have the ability or option to give that person mental health treatment and to put them in a special facility.
I see.
It's not required, but so if this defense isn't used that often, just because it's very difficult to establish that. More often than that, the evaluation comes back and it says they're not mentally, that they're not insane.
I see.
Then the defense can ask for an independent evaluation to be performed. And the other thing, that there's a gatekeeper in that. It's that up to the trial court to allow that defense to be used at trial. And again, it's based on the evaluations that were performed and so forth. I think the most recent example that I can think of was back in Jackson in 2013, where the defendant beheaded a neighbor, and everyone agreed that this person was mentally insane. And so that they even asked for a jury trial to establish that, for the jury to decide that issue. The judge, they asked for a bench trial, and I mean, even the prosecutor agreed. And so the other thing about an insanity defense, if a jury finds that the person that meets the criteria based on, the psychiatrist testifying that the person was insane, they're acquitted at that time.
Yeah.
Okay. Well, they don't get to walk out the courthouse steps. Then they are sent to the mandatory 30-day period to go back to the forensic center where they're evaluated. And then it's kind of interesting because now they've been acquitted because they've been found to be insane under the law. So now the file gets transferred and the authority to detain the person gets transferred to the probate court. And a probate judge from that point on is the person who decides how long that person will stay in a mental facility. And more often than not, it can be longer than they would have stayed in a prison system if they had been found guilty.
Okay. Well, that that prompts several questions, and we'll get to that in just a minute. On WBCK, we're talking with Attorney Rich Migala today. Attorney Rich Migala is with us. We're talking about the Jason Dalton case. So if we just recap for a second, there is a mental psychiatric evaluation that Dalton will undergo, and if I've understood you, then that will determine the disposition of the case based on any potential mental illness that could be discovered through that evaluation. We often hear about competency. That is to say, you hear folks say competent to stand trial. Is that inferred in this too?
No, it's kind of a separate analysis.
Okay.
Competent to stand trial just means at the time the person's in front of the judge and presenting their case, are they competent at that time to assist their attorney in defending themselves or being able to understand the proceedings, to be able to take part in them and understand them. So that's a whole separate arena, and it really deals with the process. It's just, are they able to understand and take part in the process? And so a lot of times, again, that's a whole separate thing. What the mental health professionals will do is try to treat the person to the point where they become competent. If it's found that they're incompetent to stand trial, then the mental health professionals there try to treat them to the point where they become, again, competent. That's a whole separate and different thing than an insanity defense. Okay. The insanity defense means at the time that the act was committed, that the person lacked the mental capacity to either realize what they were doing was wrong, or they could not conform their behavior to the standards of the law. And so that means that the defendant wasn't capable of forming the intent necessary to be found guilty of a crime, specifically those that require. There's a lot of crimes that are specific intent or have specific intent elements. So the purpose of that is to see if they were mentally competent, if you want to use that term.
Right.
And so that's different. People can have mental illnesses, and that's why, again, we used to have a diminished capacity defense, where it was you had a mental abnormality less severe than insanity, but we abolished that in Michigan as of 2011.
All right. Now, the other point that you've made is that this whole psychiatric evaluation process is triggered by the defense attorney. Then I would then presume that means the defense attorney thinks there's pretty good potential that there is a mental illness defense at play here. True?
Well, I think it's a matter of a defense attorney needing to assert that. Otherwise, they could be guilty of malpractice, number one.
Oh.
Number two, of later, the whatever happens at the trial level could be appealed based on incompetent assistance, meaning that their defense attorney was incompetent and should have asked for this. So it's kind of like, the defense attorney is kind of obligated to do it just to put on a defense, number one, and to have that question answered. And quite frankly, why wouldn't they? Now, it's very rare that it is used, and by the way, it's not limited to crimes of murder. Insanity defense can be used for any crime, and it's just not used that often, mostly because even if the evaluators come to that conclusion, it's still up to a jury to make that final determination. And it's and juries are very, very hesitant to do that, because basically you've got a person saying, or everyone saying that the person did it, they just didn't have the mental capacity to know what they were doing, but or appreciate it, or however you want to say it.
Right.
And so jurors are going to be very reluctant to let that go.
So this takes a period of time. If I recall, it's several weeks before Dalton goes back to court.
Correct. Yeah, the evaluation process isn't like going there for a day.
Yeah.
I mean, they look at him for a period of time and evaluate him over a period of time through observation, interviews, so forth.
So let's suppose there is not a mental illness component as we go forward. This case looks pretty open and shut, doesn't it?
Absolutely, yeah.
Yeah. So, this then is a pretty big step in determining which way this case goes, the outcome of this evaluation then.
Absolutely. Yeah, absolutely. And when you talk to people just around about this case in general, you think, okay, the person has to be bonkers to some degree, because there's no rational reason why this ever happened. I mean, we all see these horrible incidents that occur in workplaces because of disgruntled employees, or you see them in relationship issues where, the relationship's broken down and the person goes off. But this just, there's no rhyme or reason to this that anyone can wrap their arms around. The law enforcement officers said that, whatever answers you get, we're not going to be happy with the answers.
Mm-hmm. Well, and you've been a trooper, you've been a police officer. When you look at this and you see that the authorities have not discussed at any great length what a motive might be, what does that tell you?
I think they're struggling with it as is everyone else, because it doesn't appear to be a motive other than what he's saying.
Mm-hmm. Which doesn't necessarily make a lot of sense.
No sense whatsoever.
Yeah. All right. Well, we appreciate the perspective. That's what we were looking for, trying to understand what's happening with this case, and we appreciate your time.
Thanks, Richard. Appreciate it.
Rich Migala, attorney, Southwest Michigan, helping us understand the Jason Dalton case as it stands right now.